Today we are going to discuss the interface of intellectual property law and competition law. My dear viewers, these are the two very important subjects of law. Those who are the students of law, they know that nowadays competition law is also gaining importance phenomenally in all sectors. Of late we have witnessed that there are coming several orders imposing hefty penalties from the Competition Commission of India in different sort of matters, including matters involving intellectual properties. The sweep and scope of competition law is not only restricted to the subject matters of intellectual property, it goes beyond that, and it has its sweep and its interference in subjects like sports, in fields like film industry, in businesses like cements, oil, and so on and so forth. But intellectual property subject matters are not an exception to the application of competition law, and as and when the issue of competition or antitrust arises in the intellectual property trade, the competition law has to apply necessarily, and its provisions are to be invoked necessarily in order to streamline, govern, regulate the trade of intellectual property, or you can also call the transfer of intellectual property subject matters. My dear friends, prima facie, or when seen as a preliminary, with a preliminary perspective, intellectual property and competition law, they seem or they look to be contradictory to one another, and they seem to be diametrically opposite regimes to one another, because intellectual property law is known for what? For conferring exclusive rights to the creators of the work, to the inventors of the products and processes. But on the other hand, my dear viewers, competition law, which is not a new legislation or a new legal regime, it's an old regime, but the competition law on the other hand, my dear friends, has got a very different purpose to serve. Its purpose is to promote the competition in the market and to reduce the monopolistic behaviors, to also simultaneously curb restrictive trade practices, unfair trade practices prevailing in the market. The terminologies that I am using here, my dear friends, are comprehensible for the law students, and it is also comprehensible for the law students of competition law that these terms are no more in use under the recent or the new legislation of competition law, but these terminologies were very much in use in the predecessor act, that is Monopolies and Restrictive Trade Practices Act of 1969. But with the new Competition Act, that is Competition Act of year 2002, these terminologies have been replaced with more positivist terminologies like promoting the competition. Instead of using curbing the monopolies, the new legislation, my dear friends, uses promotion of the competition by restricting anti-competitive agreements or anti-competitive behaviors prevailing in the market. So I am coming back to the initial point which I raised here as to what is the distinction and why these two different subjects are generally understood, are generally looked at as if there is a diametric contradiction into their purports and into their objectives. Let me give you some quick objectives of the IP law. My dear friends, if you look at the screen, the objectives of the IP law are as follows. incentivizing the inventor or the creator of the work. It is also to confer a monopoly or an exclusive right. I do not want to go into the debate of monopoly because of the reason that it is an established fact in the case of intellectual property law that the monopoly conferred under the IP law is not a perpetual or an absolute monopoly. It is a monopoly which is restricted in terms of time and in terms of space. But the point that I want to convey is that the objective of the IP law is to confer a monopoly, be it for a shorter period or be it for a longer period. But it is not an absolute monopoly, because you all understand that when you apply for intellectual property protection, your work has to be disclosed in the case of patents, and in other cases it has to come into the public domain after the expiry or after the cessation of the term of the intellectual property. But as far as the objectives of the IP are concerned, the IP also throws protection of monopoly. Once you acquire a monopoly through the intellectual property regime or intellectual property legislations, there is a scope, or you can see there is a grounds of or vulnerability of infringement to take place of your work, or it can be done by a third party. So there lies a protection also under the IP laws for thwarting any prospective infringement or for enforcement in case the infringement has happened. So these are some of the objectives of the IP law, my dear friends. The most important one is the exclusivity to be given by conferment of the intellectual property law. Since we are discussing the interface of IP and the competition law, we must understand that monopoly or the conferment of the monopoly is one of the objectives of the IP law. Now, I'll take you to the objectives of the competition law on the other hand. My dear viewers, the objectives of the competition law on the other hand are as follows: promotion of the competition in the marketplace. Well, how the promotion of the competition is to be done? The strategies have not been provided or have not been listed under the Competition Act 2002, but it has been explicitly said and written under the Competition Act 2002 that any agreement or any tacit understanding, or any informal agreement or a formal agreement between the parties, between the enterprises, between persons or association of persons, in order to curb competition, or you can say in order to limit or reduce the competition in the marketplace, then that has to be declared anti-competitive, and that agreement shall be void as per section 3 subsection 2 of the Competition Act 2002. So promotion of the competition in the market is one of the agendas of the competition law. Strategies can be evolved by the courts, by the commission, or you can say the legislature can also bring forth some of the strategies by purview of the rules, by purview of the advocacy component. But in the legislation, in the main language of the legislation, strategies have not been given as to how the competition would be promoted. But on the other hand, the anti-competitive agreements have been declared void, and anti-competitive agreements have also been defined explicitly and categorically. Even abuse of dominant position shown, depicted, demonstrated or exercised by any party or enterprise is to be curbed in order to promote the competition. The competition law also promotes the competition by restricting or by scrutinizing the combinations, even the prospective combinations which have not yet realized or materialized, which are going to be materialized in the future or in the ensuing time. Even those are to be scrutinized under the Competition Act 2002 for the want of promotion of the competition in the marketplace. So one of the agendas and objectives of the competition law is to promote competition by curbing restrictive trade practices, by curbing unfair trade practices, or loosely we can say by curbing monopolies, or popularly understood, it is popularly understood by the general populace that curbing monopolies is one of the agendas of the competition law. But the Modern Competition Act 2002 does not as such explicitly says anywhere that it curbs monopolies. But if you look at the 1969 Act, that is Restrictive Trade Practices and Monopolies Act of 1969, you will find that curbing monopolies was one of the explicit agendas under the Monopolies and Restrictive Trade Practices Act of 1969. So our today's legislation in relation to competition law or competition regimen is positive in nature, or you can say enabling instead of being disabling here. So it curbs anti-competitive agreements, curbs abuse of dominant positions, scrutinizes combinations, etc. So here comes, the contrast, my dear friends. On the one hand, we have intellectual property law, which promotes and encourages inventors to invent, and it confers them the exclusivity right. On the other hand, we have a law which says that it will not allow the monopolies to succeed in the market because of the reason that its agenda and its objective is to promote the competition in the marketplace. I hope that the viewers does not need to be described that the competition has to be promoted in the marketplace because it benefits the consumers at the end. I don't need to explain how it benefits, because the more the competition in the market, the more options the consumers will have, the more differential prices the consumers will have in the market, and they will always stand benefited because of the expansion and escalation of the competition in the market. More monopolies and more restrictive trade practices if would be there in the market, then the consumers will always be at the receiving end, and they might have to end up paying very hefty amounts for buying the monopoly products, or you can say for buying the products which are either patented or which are given or conferred as exclusive things to certain creators or originators of those works. So here comes the contrast between the two laws. How to strike a balance, and how the jurists in this field are looking at this particular contrast that exists between the two laws. My dear viewers, it would be really very interesting to unfold it, that these two regimes, though looking diametrically opposite to one another and running and going parallel as if they will never meet, or they will never coincide, or they will never be in tandem, primarily they are looking as if they are going in parallel and they are contradictory to one another. The jurists of the field, the scholars of the area, see them as complementary regimes. And why do they see them as complementary regime, my dear friends? On the one hand, we have a competition law which says, or which promotes the competition. On the other hand, we have a intellectual property regime that encourages the inventions and throws the exclusive rights to the people. But my dear friends, it is to be noted, and it has to be kept in mind, that the intellectual property regime never gives an absolute monopoly. It never gives a perpetual or unfettered monopoly. It gives a controlled monopoly to the inventor to be used by him for a specific stipulated time period. He cannot use it for longer period unless he exercises abuse of the intellectual property, he does the abuse of the intellectual property. Or you may further elaborate it by going or by referring to the principles of evergreening, etc. Apart from this mechanism under the intellectual property law, that the shorter terms are provided as well as absolute monopoly is not provided, we have another mechanisms also which speak loudly about the fact that IP, irrespective of the fact that it confers a monopoly, but it is something which is necessary to encourage the inventors. It is something which goes in tandem with the competition law, and it never actually deters, obstructs, hampers the competition in the marketplace is the fact that there is a mechanism of compulsory licensing. There are mechanisms of abuse of the intellectual property available, or remedial measures for the abuse or countering the abuse for the intellectual property are available under the intellectual property regime. Well, my dear friends, I have brought a case law which would throw more light on this aspect, on the aspect of the contradiction, on the aspect of contrast between the competition law and the intellectual property, or on the aspect of, you can say, their complementary nature, because this is the case law on your screen where the Bombay High Court, my dear friends, has categorically said that the intellectual property regime is not at all violative of the competition law, and the competition law on the other hand is not violative of the intellectual property regime, and both the regimes are running in tandem, are complementary to one another, and there is nothing that can be read as a contradiction between these two regimes. There is a case law called Amir Khan Productions Private Limited versus Union of India. My dear friends, it's a very interesting case read because it involves a question of film industry, and we as a general populace or as a lay person does not ever think that there may occur an issue of competition and intellectual property in the Bollywood or in the film industry in India. Well, my dear friends, if you look at the fact sheet of this case, it's very interesting fact sheet wherein few production houses, they came together, and Amir Khan Production House is one of those production houses. They came together and they did take a decision, or decided together on one very important aspect of their trade. Actually, Bollywood industry is a trade primarily, or you must understand, apart from the recreation component, there lies a component of trade involved in the Bollywood industry, because nowadays films or the success of the cinefilms is gauged and measured on the basis of the box office collection. It is not gauged on the measure of the societal menace that has been demonstrated in the film. It is not being gauged by the message that the film conveys. It is gauged by its box office collection, and the whole issue in this case was about the collection of the revenue generated by the film houses. Well, my dear friends, if you look at the fact sheet, I am going to repeat the fact sheet once again in a more detailed manner now. There are few production houses who are into the manufacturing, or you can say making of the films. They came together and decided in concert that they will not gonna release the films produced by them or under their banner to some multiplexes from a specific date onwards. Well, it's a very interesting thing to note. Being the producers of those films or those works, they have a prerogative, or they are into the power not to release the films in certain multiplexes. So they decided that they are not going to release the films in some of the multiplexes, and the underlying issue and the reason behind taking this stringent or a strenuous decision of not releasing the films into some multiplexes was that the multiplexes were not sharing the revenue generated by them adequately to these producers. The producers were expecting more revenues, and there was a fight going on between the producers on the one hand and the multiplex owners on the other hand. Multiplex owners were making a lot of money. They had to necessarily give back the money to the producers of the film as decided in the terms of the agreement of broadcast of those films with those multiplex owners. But somehow, they were not able, or they were not adequately sharing the revenue ratio with the producers of the films. So producers of the film actually got, pissed off with this behavior of the multiplex owners and decided not to release the films into these cinema halls from a stipulated date onwards in year 2009. Well, my dear friends, if you look at the fact sheet shown on your screen, there came an information here. Those who understand the procedure followed by the Commission or Competition Commission of India under the Competition Act 2002, while taking up the informations of anti-competitive behaviors, abuse, combinations, etc., they receive the information either from an independent informant, or they receive information from the central or the state government, or they suo motu takes up the matter if they find that there is a issue of a larger importance or of a public importance, or there is a issue which they think prima facie cause appreciable adverse effect on competition in India. So they take up that matter and decide on it. Here what happened, my dear friends, there came an information against the producers who joined hands and decided not to release the films into the multiplexes. So the information alleged that the members of the UPDF, or you may call that Universal Producers and Distributors of Films, are perpetrating cartel-like activity which is violative of provisions of Section 3(3) of the Competition Act 2002. My dear friends, you must be wondering as to where the issue of intellectual property is arising here. It is not a purely question of competition law, my dear friends. It is a question which involves the issue of intellectual property also. I'll explain it how. But first you understand the facts. The producers decided not to release the films to the multiplex owners because there was a fight going on between them in relation to sharing of the ratio or the revenue generated by the multiplex owners. And this decision taken by the producers has been informed to the commission and has been alleged to the commission that this kind of a decision taken by the producers of the films under the body called UPDF, or under the umbrella body called UPDF, is a cartel-like activity, and it is violative of Section 3(3) of the Competition Act 2002. My dear friends, Section 3(3) of the Competition Act talks about the horizontal restraints, or you can say talks about the agreements between the enterprises or association of persons or persons in relation to supply, distribution, controlling, acquisition of the goods or services. But the condition over here is that the goods and services in which the enterprises are dealing are the same goods or services, and the enterprises are similarly placed on the similar pedestal. It means that they are horizontally placed. So it's a situation where the horizontal restraint has been levied, or a horizontal cartel has been invoked in order to do what? In order to restrict the distribution of the movies or cine films into multiplexes. And you see, my dear friends, here multiplex owners have come to the CCI and they have informed the CCI by purview of Section 19 of the Competition Act 2002, and in their information they have alleged cartel-like activity exercised by the producers of the films. It's a matter of scrutiny whether they were actually carteling or not, or they were actually unanimously imposing or restricting the release of the films into the multiplexes. It has to be investigated. So for the sake of digging it deep, or for the sake of investigating the matter further, my dear friends, the Commission directed the Director General under Section 26 of the Competition Act 2002 to investigate the matter. And if you look at the another allegation here, my dear friends, it has also been alleged that these production houses who jointly control approximately 100% of the market share for production and distribution of Hindi motion pictures, they, by organizing themselves under the umbrella called UPDF, took a collective decision not to release films to the multiplexes from April 4, 2009 onwards, with the objective to extract higher revenue sharing ratio from the members of the multiplex owners, and this cartel-like activity has appreciable adverse effect on competition in India. This is the allegation of the multiplex owners, my dear friends. So the whole issue basically was in relation to sharing of the revenue generated by the multiplexes owners, but the multiplexes owners had gone to the Competition Commission of India alleging that it's a cartel which producers of the motion pictures have formed, have resulted into, and they are restricting the distribution of the cine films into the multiplexes by entering into this cartel like activity. Well, my dear friends, as far as or so far as the discussion goes or discussion is concerned, it seems that this decision of the producers of the films against few multiplex owners, it seems an arbitrary decision or a discriminatory decision prima facie, because no enterprise can refuse like this unless they have a substantial reason to justify that they are going to refuse, because refusal to deal into their work is also an abuse of the intellectual property, and it's a work, my dear friends, which is intellectual property protected work. It's a copyrighted work on which they are owning a ownership. If you look at the cine films are what kind of works under the intellectual property? I have explained in my previous lectures many times that cine films are the works which fall under the category of copyright, and they are copyrightable if found original. If they are not substantially copying the others' works, then copyright lies in the cine films. So my dear friends, on the one hand we are saying, and we are witnessing here, that being the producers of the films, they have the copyright on those films, and it is their prerogative under the copyright law to distribute their films according to their discretion. They are not, here under the copyright law restricted in any way whatsoever. So it is their prerogative and privilege to decide about the distribution of their films. But it is also to be taken note of that copyright law, apart from having this encouraging right where the owners of the work have a right of distribution, the copyright law also says that the people will try to withhold the work or will try to restrict the distribution of the work, and if the work's dissemination will get hampered or withheld from the public, then provisions of compulsory licenses are available under the copyright law, and the copyright board can be approached, wherein under section 31 of the copyright law, my dear friends, any person interested in taking up the work as a compulsory license work can approach the board and can seek the compulsory license by meeting out the requirements of section 31 and by proving that the concerned work has been withheld from its dissemination by the owner by not releasing or by not distributing this work adequately. So my dear friends, here the producers of the film, they, in their defense, let's see what are the defense taken here or the defense pleaded here by the petitioners. In this case, the petitioners here have challenged, first of all, the jurisdiction of the commission to initiate any proceedings under the Competition Act against the petitioners on the following grounds. They said that the commission does not have the jurisdiction to entertain this matter, and they have wrongly taken up the matter because it is a matter which involves a question of intellectual property, and it is a case of copyright where they own a copyright on the cine films or on their respective works, and they have a prerogative and they have a privilege and exclusive right to decide on this, to whom to release those films and to whom to refuse to release those films, or you can say to whom to distribute and to whom not to distribute. But since copyright law has a measure, inbuilt measure or a mechanism which says otherwise, which says if the work or its distribution or dissemination would be withheld from the public, then compulsory license can be sought by the independent seeker under section 31 of the Act. But here the matter has gone to the Competition Commission of India, which has nothing to do with the intellectual property as far as the intellectual property rights are concerned, as far as the intellectual property laws and legislation are concerned. Competition Commission of India has not been made the forum anywhere in any of the intellectual property legislations, but still the matter has been taken to whom? To the Commission. And it's interesting to note that the Commission was confronted in the very beginning with the question of its jurisdiction in this matter. Well, my dear friends, the allegation of lack of jurisdiction goes here on the screen in front of you. The petitioners alleged that the Commission lacks the jurisdiction to take up the matter because exhibition of a feature film, which is a subject matter of copyright exploitation alone, is specifically excluded under section 3(5) of the Competition Act, and hence the proceedings initiated against the petitioners are without any jurisdiction. This is the first allegation, or you can say first point, in order to prove that the Commission lacks the jurisdiction to entertain this matter, because there is a section called section 3 subsection 5 under the Competition Act, which says that any subject matter of the copyright or patent law shall be beyond the purview of the Competition Act. This is what has been alleged here, but what has been actually put under the Competition Act by purview of section 3 subsection 5, that has to be looked after, that has to be interpreted, that has to be deliberated and brainstormed, which we are going to do today. So my dear friends, here the question comes. Now I believe you are acquainted with the metrics involved of different provisions here. There are several provisions which are involved here. On the one hand, you see, Competition Commission has got the power under section 19 to take up the matter on an information received by it and order the investigation under section 26 of the Competition Act, where the Director General will investigate the matter deeply and submit its report, and then the Commission has the powers under section 27 of the Competition Act 2002 to impose hefty penalties on the errant opposite parties. On the other hand, we have section 3 of the Competition Act 2002 and specifically section 3 subsection 5 of the Competition Act 2002, which says that any act or any reasonable restriction imposed or any restriction applied by the person or an enterprise in order to protect the work or in order to thwart the infringement to be done by any person shall not come under the purview of the Competition Act, and no preceding clauses of section 3 will remain applicable on those subject matters because of the fact that those rights are being exercised, as those rights are conferred by the intellectual property legislations on the owners of those intellectual properties in order to do what? In order to trade into their goods or into their works smoothly, and in order to trade into their works without any sort of impediments. But what has been alleged here is that the competition law excludes and ousts completely the issues of intellectual property from the purview of the competition law. This allegation or this interpretation is a misinterpretation of the relevant provision of the law. The relevant provision of the law, that is 3 subsection 5, nowhere postulates this interpretation. It postulates a different interpretation altogether. It nowhere says that the competition law excludes and ousts all the issues which involve intellectual property into it completely out of the purview of the competition law. It does not say so anywhere. On the other hand, it says what? It says that if the right has been exercised in order to protect the protection of the intellectual property or in order to thwart the infringement of the intellectual property, if any term has been imposed, if any condition has been imposed, then the person imposing that condition or that term shall not be made liable for any sort of anti-competitive agreement or for any violation of the provisions of section 3, because whatever he has done here under the exercise of the power conferred to him by purview of the intellectual property law. So that is how, my dear friends, these two laws, which seems to be contradictory to one another, but when looked at with precision, with meticulous perception, are found to be complementary to one another and are found to be supplementary to one another and are found to be running in tandem, because competition law nowhere excludes outrightly the subject matters to be taken into consideration by the Competition Commission of India if it is a question of anti-competitive behavior, but it simultaneously involves the subject matter of intellectual property. It says that it can be taken up by the Commission, and the Commission does not lack the jurisdiction in this matter. It has the jurisdiction in the matter if the right is exercised, or if the condition imposed is a condition which is very much within the powers of the person while imposing that condition by purview of the IP legislations, and if it is imposed on what reasons or for what reasons, if it is imposed for the reason of thwarting the infringement or for the reason of protecting the intellectual property or its protection. Otherwise, if anybody is found imposing any unfair condition on anyone, then that shall be, that condition or that agreement involving that condition shall be violative of the Competition Act, and that shall be void by purview of section 3 subsection 2. Well, my dear friends, here I would like to pause for a moment and would like to give you a very lay example in order to make you understand this analogy. Here we had a case of a cinefilm or of a motion pictures. What had happened here? The owners of the cinefilms, or you can say the producers of who are actually the owners of the cinefilms, they have restricted the distribution and dissemination of cinefilms into few cinema halls, and in their agreements they have written that if those cinema halls will be distributing those films, then they shall be violating their intellectual properties. Here, this kind of restriction imposed or a condition imposed is not for the purposes of protecting their intellectual property, my dear friends. It is for the purposes of rather exerting their pressure, and it is for the purposes of garnering the revenue generated by the multiplex owners, or it is for the purposes of usurping, you may say, the revenue generated by the multiplex owners. Had it been a case where multiplex owners are being deprived of the distribution because they have been found in the past involved in the imitation, infringement of the works of the owners of the cinefilms, then this kind of imposition of these condition or imposition of restriction would have been what? It would have been a legitimate condition imposed here. But since it is not for the purposes as stipulated or envisaged under section 3(5), rather it is imposed because they want to exert their pressure and they want to negotiate on the revenue sharing ratio ultimately. Had it been a case where the multiplex owners have been found by the producers of the film doing what? Doing the infringement of their work. Are they infringing their work? No, they are not infringing their work. They are distributing, or you can say disseminating, or you can say they are communicating the work to the public as supplied by the producers of the film. They are not making counterfeit or piracy. They are not engaged into piracy of their works. So here 3.5, which is tried to be construed very narrowly, which is tried to be construed in a very different context and tried to be misinterpreted actually, has been held by the court in this case that it has got a very meaningful interpretation and it cannot be misinterpreted like this, the way it is being tried to be misinterpreted by the producers of the film by imposing the conditions and by alleging that the commission lacks the jurisdiction in the matter. Well, my dear friends, I would like to take you to the relevant section, that is section 3.5, and if you look at the language of section 3.5, which I have just explained to you cursorily, now we will look at the black written law and we will deal with it meticulously. Let's see what does it say. It reads, nothing contained in this section shall restrict the right of any person to restrain any infringement of or to impose reasonable conditions as may be necessary for protecting any of his rights which have been or may be conferred upon him under Copyright Law, Patent Law, Trade and Merchandise Marks Act, the Geographical Indications of Goods Act, the Designs Act, the Semiconductor Integrated Circuits Layout Designs Act. Just read it again, my dear friends. What does it say? It says nothing contained in section 3. And what is contained in section 3? Section 3 talks about anti-competitive agreements. It says that any anti-competitive agreement entered into by the enterprises or amongst the enterprises in order to control, limit the production, supply, distribution of the goods or services shall be void. That kind of an agreement shall be void if it causes appreciable adverse effect or if it is likely to cause appreciable adverse effect on competition within India. Those who are the students of competition law, they understand the nuanced meaning of appreciable adverse effect on competition in India and they can easily elaborate it on their own. But as far as the present discussion is concerned, I'd like to just tell that appreciable adverse effect of the competition in the case of 3.3 is a presumption, but in the case of 3 subsection 4 is to be proved. And how is it to be proved? It is to be proved by referring to the parameters provided under section 19 of the Competition Act. There are certain clauses or subsections of section 19 wherein the exhaustive, not so exhaustive but illustrative measures or illustrative parameters are provided, as and when it can be called that the particular agreement done among the particular entities or entered into particular entities is causing appreciable adverse effect. So here the non-release or non-distribution of the motion pictures produced by these producers who have decided together not to distribute those films into some multiplexes, this activity or this behavior, when it is a behavior in concert or if it is a behavior which is basically a behavior getting reflected into their acts on the basis of the decisions taken by them unanimously or with the consensus or with the concert, this behavior shall be going to cause or shall certainly going to cause appreciable adverse effect on competition in India, because these multiplex owners will not be able to demonstrate or distribute that work, they will not be able to release those pictures, and very few multiplex owners in a particular relevant region or in a particular relevant geographic market will be allowed by them. Say for example, in one particular relevant market there are 10 multiplexes available, and out of those 10, if 5 have been refused to distribute the motion picture or a cinefilm, only 5 will be distributing that or communicating it to the public. So those 5 who will be communicating it to the public will be in a dominant position, will certainly be charging more, or there is a likelihood of them charging more, or there is a likelihood of some adverse effect to occur on competition in the relevant market here. So if we look at this case, then we come to know that section 3.5, which has been tried to be misinterpreted here by the counsels of the appellants by saying that it completely excludes and ousts the intellectual property issues from the purview of the application of Competition Act, is actually wrong, or this allegation is completely bunkum, because the law nowhere says so. The law on the other hand says that the competition law will be applicable on the issues of intellectual property, but it will not be applicable on the issues of intellectual property or agreements involving intellectual property if there are certain conditions imposed by the owners of the intellectual property in order to protect their work, which are necessary for protecting their work from any infringement to occur or from any violation to happen. In the later case, when the violation, the fear of violation is there and some conditions have been imposed, the Competition Act will not be applicable, and if such condition has been imposed by the owner of the intellectual property, then that condition will not be arbitrary, will not be anti-competitive. But if the condition has been imposed without the fear or without the apprehension of any sort of infringement to take place, or if it is not within the purview of section 3.5 as envisaged under section 3.5, then in that case, then that shall be called the anti-competitive act. So my dear friends, here we have been able to draw an analogy between these two seemingly contradictory legislations, but not actually contradictory in reality, as has been proved by purview of this discussion and these various relevant sections of these two different laws. If you look at the judgment or the decision of the Bombay High Court in Amir Khan Productions versus Union of India, so my dear friends, I would like to take you to the very important and a pertinent observation of the Bombay High Court in this case, which reads as follows and which says that the counsels in this case of the petitioners have tried to misguide the court or have tried to redraft the language of section 3 subsection 5. The language has been tried or attempted to have been redrafted as if it does not at all, takes into its ambit the issues involving intellectual property or agreements involving intellectual property. I'll give you a very lay example, my dear friends. Suppose I am dealing into patents and I want to confer those patents or transfer those patents to the seeker or to the licensee. I, being the owner of the patent, can decide on the agreements or on the terms of the agreements with the licensee, but if I would put the unreasonable conditions and terms in the license, even though I am the owner of that particular property, still if I put unreasonable conditions, if I put some unreasonable, unfair, discriminatory conditions in my agreement, then in that case, my dear friends, my agreement shall be an agreement to be scrutinized by the competition authorities, and it shall be a very legitimate way or a legitimate modus or a method of the competition authorities to investigate and scrutinize such an agreement which involves unfair, discriminatory and non-reasonable conditions on the licensee. But if I impose certain conditions in the agreement in order to protect my intellectual property, in order to, I am imposing some reasonable conditions which are necessary for me in order to protect my right, then my dear friends, the competition authorities cannot scrutinize that particular agreement and they cannot label it as anti-competitive agreement, because that is out of the purview of those competition authorities as made out of the purview of those authorities by purview of section 3 subsection 5 here explicitly. So in nutshell, we can say that these two laws, which are contradictory, seemingly contradictory or generally understood as contradictory, are not actually contradictory, are rather complementary to one another, because On the one hand, monopoly has been conferred, and in order to exercise monopoly and reap its fruits fully, or reap the fruits of the monopoly fully, you see, competition law comes into the picture, which says that will look after and take care of the interest of the monopolizer as well as the interest of the public at large, by upholding their rights and by taking into consideration their rights also. So with this note, my dear friends, I would take leave now, and I will also discuss one more interesting case read on the similar aspect, but that case read would be involving a question of automobile sector, unlike this case read which involves a question of motion pictures or cinefilms. Have a very good day, my dear friends. With this, I rest here. Thank you very much.